Mr. Nunez, I see that we have those two individuals, Ashley's iPhone and iPhone, as rejoining and are in the waiting room. If you can please send them a chat and tell them that they need to identify themselves and connect to audio before we will allow them to participate, and that they can view the proceeding on YouTube if they're just here as a member of the public. All right, thank you. All righty, now let's get to the right case. Calling cause number 2021-0D03011, State of Texas versus Juan Antonio Rodriguez. May I have announcements, please?
Good afternoon, Your Honor. Ray Duke for the state. The state of Texas is ready to proceed.
Good afternoon, Your Honor. Teresa Caballero on behalf of Juan Rodriguez, and we're ready to proceed.
Mr. Rodriguez is appearing remotely from the downtown jail. I believe this was originally scheduled solely as a status conference. After we had our mistrial, I did set it, but the request had been to add to it a bond hearing. Are you ready to proceed on that bond hearing, Mr. Duke?
Yes, Your Honor.
Okay. All right, Ms. Caballero, you may proceed.
Thank you, Your Honor. I would ask the court to take judicial notice of the evidence adduced in the trial that we just had that was mistried, and the fact that my client has been in jail for about 3 years and 2 months. And he has a very high bond. I think it's set at $1 million. And the reason for that is that after the homicide, which is being ascribed to my client, but which we deny, he left the alleged scene of the crime and he went to Juarez, but he came back 3 hours later. And that has also been sworn to testimony on the stand by the El Paso Police Department. So I think the original assessment of $1 million was based on the fact that he, quote unquote, fled from the scene of the crime. But that's not really an accurate description of what happened. Plus, he was back the same day by his own accord. He's an American citizen. He's lived his entire life here in El Paso. The court saw and heard from his family during the trial. He is not a threat to society. He's not a flight risk. And we do think that $1 million at this juncture is way too much. I don't foresee the state getting 12 jurors to agree on guilt beyond a reasonable doubt on the charges as alleged. And the court can make its own evaluation of the evidence. And we would ask that my court be granted a bond that is very reasonable, that his family can make. I did apprise his family of this hearing, and I told the mother originally was at 9, but then it was moved to 3. And I do believe they might be online, but the court saw them in the courtroom day after day or out in the hallway, that he has a lot of family support. They have, family homes that they're willing to put up as collateral. But Your Honor, I'm asking for something around $60,000 as being a reasonable bond at this juncture.
Okay, tell me a little bit about where, if he is able to bond out, where he's going to be living, things of that nature.
Well, he would be living with his mother and father, and I'm going to ask Mr. Rodriguez to give us that address. Juan?
Mr. Rodriguez,
Yes, ma'am.
can you hear us?
Yes, ma'am.
Your parents' address, Juan?
14136 Rainbow Point, 79938, El Paso, Texas.
Okay. Anything else, Ms. Caballero? And you said, so that was my question, is how much can your client, family, however, afford? And you're telling me a $60,000 cash surety bond?
Yes, Your Honor, about $60,000. They had another home that was referenced during the trial, and that home was sold to pay for legal fees.
Okay. All righty. Do you have anything else, Ms. Caballero?
No, Your Honor.
Mr. Duke?
Yes, Your Honor. You heard all of the evidence in this matter. And it is true that the defendant did go to Juarez and that he did come back. And quite frankly, I think the only reason he was even held at the bridge is because he had a failure to appear warrant out of Crane, Texas. My understanding looking through Odyssey is he has done his time on that. He's time served that particular charge out. But that's the only reason that he was held at the bridge. It wasn't because he was a suspect in the murder. It's because of the failure to appear warrant out of Crane, Texas. I think this court has heard everything it needs to hear, and then it can make whatever decision it believes is appropriate in this matter.
So is the state opposed to a bond reduction, and is the state opposed to something in the range of a $60,000 cash surety bond?
I would be opposed to a $60,000 cash surety bond, Judge. I think the $1 million is probably a bit much. I'm thinking in the neighborhood of probably 300,000 or 400,000 would be appropriate, in addition to a PR bond component because of the nature of the charge.
Did either of you all, I know I mentioned before that we have several individuals in the waiting room. Did you all have, or were you all going to call any witnesses or anything for the court? Okay. All right.
Your Honor, I would like to cap it out at, if the court were to order 300,000 to 400,000, which I do think is excessive, he would not probably be able to make that. So 60,000 or so dollars would require some stiff collateral from my client's family. And he's not going to flee or put them in a position of having to lose a family home.
Mm-hmm. Mm-hmm. Yeah. So, of course, unless you all have something else, because he's been in custody partially because he's been in custody for so long, but for all of the things that you all have stated, obviously, but I'm not at 60,000, Ms. Caballero.
Okay.
I'm at a significant, especially in light of what the current bond is, a significant reduction. He's going to be at a $250,000 split bond, $100,000 cash surety, $150,000 PR bond. To the extent they can provide, I get back and forth from PR bond about having some type of monitoring device.
Okay.
If they are able to have some type of monitor on him, then that is going to be part of his bond conditions. If not, he's going to be required to have a portable alcohol monitor with GPS capability on it.
Okay.
Frankly, might be useful in light of the circumstances.
Okay.
Drinking and whatnot. Subject to testing, obviously may not leave El Paso County without court permission or change his place of residence without court permission, understanding he'll be living with family. Report once a month in person to the PR bond office, obviously appear for all hearings. You're to have no contact with not only the family, but any of he is to have no contact with any of the witnesses. Obviously, the concern, with some of the witnesses that the state called, you're to have no contact with them. And Mr. Rodriguez, you need to understand that the court is very much aware, not just in your case, in any case, that sometimes individuals make contact, not the person under the order, but you're going to be the person under my order. And so, Ms. Caballero, you need to advise him that
I will.
If he gets any kind of contacts, he's the only one that's at risk of getting his bond pulled. So no contact, no third person contact, meaning you're not telling, your cousin or anybody else to contact any of those individuals. They're to have no contact whatsoever.
Yes, sir.
¿Qué más? Subject of testing, no drinking, no illegal drugs. Any other conditions, Mr. Duke?
Just if he has a passport to surrender it, Judge, and then obviously no travel to Mexico.
That'll be part of the conditions. That's good. We'll see where we are, but in addition to that, that's going to be the order on the bond.
Thank you.
Ms. Caballero, while we're here, this is also a status conference. Have you all,
I reached out to Mr. Duke.
how quickly can we get this trial set?
Your Honor, if I may,
Yes,
I
ma'am.
did reach out to Mr. Duke. We talked about any practical decisions that may have been made. And I do think that because of the change in administration,
Mm-hmm.
I don't believe Mr. Duke is in a position to say this or that, other than he believed that it would probably be retried.
Mhm.
If we could set it, Your Honor, I'm thinking for either late January, early February, at least for a status hearing, so that we can get this on track for whatever is going to happen in this case.
Mm-hmm. Myrna, what, if any, trial settings do we have available in January and February?
I think he said status, Your Honor.
I know, but
She wants to get it tried. I understand, Judge.
if I don't secure you a trial date right now and your client isn't able to bond out, frankly, I'm asking that question, and I'm 95% sure Myrna's going to come back and tell me we're all full.
Well, I know I'm full.
And so, okay. I just need to ask. I just need to ask in case there's any chance in the world that I can secure you all some type of trial setting. And if we can do it, if we have something February, March, you'll obviously still have your January status conference, but at least I can get you a trial date in
Judge,
Monday.
on February 7th, there's no special settings.
Okay. Any chance we're going to set it?
Okay.
We're gonna set it on February 7th, and then January 21st will be our status conference. And the 4th will be our final hearing plea deadline, all with a big old asterisk on it. Except for the status conference, we can do that for sure. Okay? I just don't want to
Yes,
leave you without a trial date. Alrighty.
Thank you.
Okay. Thank you, Your Honor.
Honor.
Very much for your time.
Thank you. Thank you. Bye-bye.
Downtown.